it's an action if it's a denial or limited authorization of a requested service, including the type or level of a service. And there's other pieces under managed care of how they define action. I didn't put them all here. But so the thought and the argument here could be that if a person, say a person is asking for a type of service or their level of service, and their person-centered plan says they get this service in a 3-bed group home, and in order for it to be community for that person, they're supposed to not really have any modifications of their plan, and they're supposed to have this type of access to the community. And we are sort of thinking the argument here could be that if that person's not really being able to access those services as they're described in the person-centered plan, that they may not be accessing the type or level of service. And so the question here is maybe, well, what if I'm not in managed care and action's not a type or level of service? Then this would be where a Goldberg versus Kelly, which is the big due process case, you would be able to argue that under Goldberg versus Kelly, you can't have more rights where something is subcontracted away, part of a whole. In other words, if managed care is subcontracting away part of Medicaid, and you would have an extra level of rights there that you don't have in the regular fee-for-service, fee-for-service should also have that right. Which is maybe not the best explanation, but basically we would be arguing that everybody should be able to define the term action in this instance as the type or level of service. And so you'd be arguing what I'm supposed to be getting in my person-centered plan and what the definition of how my community services are supposed to look like is not being offered to me, and therefore I'm being denied the type or level of service that I'm supposed to be getting, and therefore I want to appeal that. And the purpose of the appeal would be trying to get to, within your state, either the third-party administrative law judge or hearing officer who could then order whatever agency appropriate to fix the problems that the person is experiencing. Now this would be, it would probably most work well for an instance where it's really clear that the services the person is currently receiving are not really the services that are described in the person-centered plan. Because you're trying to argue about not being a type or level of service, you'd really have to prove that they were supposed to be getting this 3-bed group home with all sorts of freedoms and the rights to privacy and all of these things, and they're not getting it, and instead their situation looks completely different or different. But this could be a mechanism in terms of the Medicaid appeals to try to get something remediated. I'm sorry, it's not moving forward.
I think if you click on there it goes. Is that working?
Ah, now it's gone too far. I'm sorry for my technical difficulties. This is not.
It?
There we go. Okay. That's better. And so in this instance where we're saying, okay, let's define the lack or the failure to provide the type or level of services as an action so we can appeal it, this is where we're trying to get into due process, and in appealing it saying we want to be able to have a fair hearing and go before the administrative law judge. Now another part of due process that could come into play in these person-centered plans is, are people being discouraged? And so there are cases where been held discouragement infringes upon due process because if a person's being discouraged from asking for a certain type or level of service, that is essentially a denial of that service before they're even really able to ask. And discouragement can happen when a person's requesting for services. It can happen if they're if they're being told, well, don't file that appeal, or if they're saying, well, don't file a grievance or complaint against this, or if in their person-centered planning process, it's really not as, in person-centered planning, it could be discouragement if the services the person's asking for, if they're saying, I want to be, this level of involved with the community, and I want to do supported employment 4 days a week, and the person's saying, well, no, you should just do it 2, that's sort of a denial before they even get to asking for it and going through the, submitting the plan and getting the plan approved or denied. And discouragement is sort of a very, it's hard to find the line in discouragement of whether or not somebody's being denied before they have a chance to ask, which would sort of trigger due process, or if they are just engaging in a clinical or a treatment discussion. And so not every time a person says, like a care manager or the person helping the individual with their care plan says, you shouldn't, because of the way the program's set up, 4 days a week works well based on these circumstances, or this is the plan of care in the rules and types of things that we think makes a good program for you. There's a difference between saying, no, you can only have 4 days a week because that's what your budget allows and that's what we say is appropriate, versus somebody trying to help a person create a good plan. And I know that's not a description of a really clear line, but it's because there's not a super clear line in discouragement. And so if you're saying that you were denied because you didn't really have a chance to ask for the service, it may be a hard argument if it's not really clear that you were told, no, you can't even apply for the service. But it is part of due process, and it could be an argument for enforcement to say, they told me that I had to sign my plan the way it was written or I didn't get any services. That's very coercive, and it could be that that's violative of the due process, violating the person-centered planning process the way that's supposed to go, but it's also basically telling the person these are the only services you can have and you can't ask for more. There is a good piece, it's very small, in the preamble to the rules and then in the comments section where CMS says that a person can always appeal an action even if the plan is signed. And I put the citation there, and I think that was in response to a comment where the commenter was talking about the type of instance where individuals are told, sign this as it is, even if you don't agree with it, because we have to get it in, or we're running out of time. And so CMS was very clear and said, we don't think we need to add this into the rules because that right is already protected under the due process regulations. And I would note here, though, that it does say that it's a right to appeal an action, so that goes back to, was a Medicaid service denied or the type or level of service denied. And as I said, these are all sort of our initial thoughts about how somebody may be able to enforce these rules, and I think we'll evolve more as we go along thinking about new ways to do it. Sam, oh, there we go. So that would be the Medicaid appeal route and how you could try to access the Medicaid appeal route to enforce the home and community-based regulations, and trying to put it forward as, because of failures in the person-centered planning process or because of the way my services are currently being implemented, I'm not getting, or was not able to ask for the services that I wanted or that I'm needing. That would be the way to access the Medicaid appeals process. The other things that could be an avenue for enforcing regulations would vary quite a bit by state, because different states may have different compliance mechanisms that could be used to try to enforce these rules. For instance, if a person's in a managed care plan and their home and community-based services are offered under that managed care plan, they may be able to file a grievance. And the grievance in managed care, you can essentially file a grievance for anything that's not an action. And the grievance system has timelines for when things are supposed to be responded to, and there is a system set up there. A lot of people dismiss the grievance process as not being that helpful, but it is helpful because they are supposed to respond to you, and they are supposed to address your concerns, and they also usually have to report on complaints and grievances, and so if you are complaining about the care offered through your managed care plan, it is a valuable tool. And for this, if the managed care plan is the one in charge of provider enrollment, it could be very helpful because that would be letting the managed care plan know that this provider, if you're in a provider-controlled setting, is not providing the care in the way they are supposed to according to the home and community-based regulations.
Yes. Sorry. This might be a good point to interrupt and ask one of the questions from the audience. Several managed care programs have their case management staff facilitate the person-centered plan, and does this conflict with the conflict-free case management provision in the rule?
So that was one of my immediate thoughts also, because I've had experience where you don't always think that the managed care coordinator or case manager may be doing what you may think an independent person would be doing. And the way that I read the rules, I don't think that falls into the conflict of interest standards that they've set forth. It seems to be allowable. And they actually say something about it specifically, and if you give me 1 second, I will try to find the note for it, because I just saw it the other day.
Elizabeth, were you looking at the note where it talks about rural areas?
It's around there. Do you have it, Elizabeth?
I'm not finding it right away, but I think that there is one exception to allow case managers to do, but that it might not be case managers, it might be for assessments actually, which is different. But if they're in a rural area and there are no providers available, then there can be some exceptions to the conflict of interest rules. But I'd rather quote that from the statute.
So they talk a little bit about it in the independent assessment section and in the care planning section, and it seems like CMS envisions that a managed care entity could do case management. They don't seem to be trying to change that. And that sub-discussion is on page 2992 of the Federal Register, where they're talking about assessments in the conflict of interest standards part. But what I remember reading was that it wasn't going to prevent case managers for managed care companies being the people who do the person-centered planning process for the individuals. Are there any other questions, Sam? Okay, I'm going to assume not, and we'll keep going with the state compliance mechanisms. So like I said, you could file a grievance with your managed care system if you're in managed care for home and community-based services. Most states also have some form of a customer service or complaint mechanism. They may or may not, they may vary as to whether or not they're effective by state. One thing that a lot of people are thinking about is whether or not the state licensing agency could play a role in enforcing these regulations. And the thought here is that the state has this existing system in which they could make sure that the licensing agencies who are out there looking at provider facilities and measuring them on a bunch of other things to meet the regulations for their license, could also be looking at whether or not they're meeting the home and community-based standards. And if they are looking at home and community-based standards, then there should be a mechanism for an individual to complain to those state licensing agencies about the provider or not meeting the standards set forth for that individual. Now, some state licensing agencies are fairly good about following up on complaints, and I think some states they're not as effective, or individuals who complain don't find them as effective. But this could be one mechanism to have enforcement. And I think one of the ways to look at enforcement, especially as we're going through the transition plan process and trying to make recommendations to states, is to figure out what is going to be the most effective way for states to do this, and at the same time a way that states will see as feasible. And so as an advocate, it may be a good idea to look at, okay, what existing systems do we have that we can adapt? Therefore, the state wouldn't see it as a lot of resources or trying to start something new, instead we're trying to sort of work within the existing programs in the existing systems to just add something else to it. I think a lot of times states are very hesitant to start something new. And so if you can identify a good way to use existing compliance mechanisms, that would be helpful or more likely to happen. Another example of that would be provider enrollment procedures or rules and regulations. So I think a lot of the concern for compliance is going to be how people receive services in provider-controlled settings and how the modifications are treated. And almost all providers have to go through a provider enrollment process. And to use that process to feed information about whether or not providers are good or bad on community-based services could be a way to ensure that the providers are meeting the standards set forth by the HCBS rules. So this could work in terms of a person could complain to the provider enrollment section of the state or agency or managed care organization, and in filing a complaint, either the provider enrollment department could try to fix it immediately, or it could become part of the provider's next go-round for enrollment. So that would be one mechanism that could be used. And another thought about this is, to diverge a little bit but keep on the provider enrollment process, is if the state used a survey, say at the beginning of a person's person-centered planning process, that inquired of the person in an accessible way without provider influence about, what is your experience like in your setting, in all of your settings? Do you, have true access to food? What does your privacy look like? Are any of the person's modifications, do they work the way they're supposed to? A survey would identify sort of all the pieces of the HCBS rules and what the person's experience is supposed to be like. And that information would not only help in the person-centered planning process to make sure that all of their needs are currently being met, but it would also be a way to identify the information that would be necessary to affect provider enrollment and say, hey, this provider is not doing what they're supposed to, and therefore either needs to have a compliance plan, or their enrollment should be questioned, or their license should be questioned. And so one way is that if the person-centered planning process had that kind of pre-survey, that information could then be fed to the provider enrollment section and the state licensing section, so that when that provider's licensing or enrollment came up, it would be part of the review process. Another existing state mechanism could be that some ombudsman's programs are looking at community-based settings, and so the person could call the ombudsman program and have their complaint try to be addressed in that mechanism if they're in a provider-controlled setting. And not all ombudsman programs look at community-based settings. A lot of them are focused on nursing homes and some assisted living facilities, although some states use some home and community-based services for assisted living, which may not be able to continue as we move forward. But there are states that have these expanded ombudsman programs, and it could be a good way to take an existing system and expand upon it to make sure that things are in compliance. That would probably be an expansion of resources for the state, which is not out of the question, but it's a program that already knows how to enforce regulations, and so it would probably be fairly effective. Some states also have human rights laws and commissions that may be able to do a little bit of enforcement. Now, this is going to be very dependent on state laws. Some states have very robust human rights commissions or human rights protections, and then they have established mechanisms where you can make a complaint and try to have some of those things enforced. So that would be very dependent upon a state or even a locality. Some localities have stronger protections or agencies. But it would be something to look at in your state or your locality. The last sort of idea that may or may not work based on your state or local rules would be that if, to use the State Administrative Procedures Act to protest a decision by the state agency or other local agency to not, sorry, let me back up. The State Administrative Procedures Act could be a way to say, okay, this was an agency decision that affects me, and I think it was a bad decision, and I want to have somebody else review it. And usually that means, say, for instance, the State Department of Health and Human Services is the one making decisions about your plan of care, and they agreed that you should have all of these home and community-based services, and you say this is not, my experience is not reflected in this plan of care, and I want to have things changed or adjusted, or you make a complaint and they say that it's not true, and you're trying to protest that decision. Sometimes the State Administrative Procedures Act gives you an opportunity to protest decisions by state agencies. And so this would be a mechanism when their decision doesn't really rise to the level of an action and you can't get to a third-party hearing, the hearing officer, by making an action. This could be a mechanism to try to get in front of the third-party hearing officer, like an administrative law judge, for other decisions. And it's going to be very dependent upon your state laws and whether or not you can take this kind of decision through that procedure.
Elizabeth, before you go on to the person-centered planning, I did find the provision, I believe, that would answer the individual's question. Could you possibly read it to us again, Sam, so I can see if I'm on the right track here?
You mean the question? The question was if the managed care program funded through Medicaid has its case management staff facilitate the person-centered plan, does that conflict with the conflict-free case management provision of the rule?
It seems to me that it would, and then I think Elizabeth was trying to find the section. It says the state must provide assurances that necessary safeguards have been taken. So I think that that's what Elizabeth was saying. It depends on, a lot of it depends on how well the state has set up the safeguards. But it says for both agencies and individuals and agents who are conducting individualized independent evaluation, independent assessment, and service plan development, they have certain conflict of interest requirements. And the standards apply to all individuals and entities, public or private. At a minimum, these agents must not be any of the following. And it says providers of state plan HCBS for the individual, or who have an interest in or are employed by a provider of a state plan HCBS for the individual, and then they have an exception. Except when the state demonstrates that the only willing and qualified agent to perform independent assessments and develop person-centered plans in a geographic area also provides HCBS, and so the state would have to devise conflict of interest protection, including separation of agent and provider functions within provider entities, which are described in the state plan. So basically, if they can't find another provider qualified to do the assessment, they would be able to set up sort of a Chinese wall that would separate the agent from actually carrying out the person-centered plan. Is that your understanding too, Elizabeth?
Sort of. I think that a lot of managed care organizations that have care coordination or case management, when you look at the waiver, it's described as a very separated entity, and they describe the conflict provisions. So I don't know that the conflict provisions in these rules are going to change much about that, because the way that they've already, at least some of the ones that I'm aware of, have set it up, the way they describe it meets the conflict of interest standards, because they say that the care coordinators or the case managers that are under the managed care entity are in a different department and are separate and apart from, and there's no communication with utilization review. And so they set it up such that it will meet the conflict of interest standards. And so that's why I think that it won't really affect the care coordinators or case managers in a managed care company doing the person-centered planning. I think that most of them will be able to meet the, as Elizabeth said, that sort of wall between decision-making about services and care planning. I could be wrong, and I would welcome being wrong on that.
There's another question to follow up on this, asking whether the conflict of interest provisions that we just read aloud are applicable to 1915I only, or does it also apply to 1915C?
I think the section that Elizabeth was in was 1915I.
Yeah, I remember there's one section that doesn't have the conflict of interest provision, but my interest, I believe, and I'm going to have to look it up again, that there's sort of another, that there's at least some discussion of conflict of interest even in 1915C.
Right. I do think it's right that that provision we were looking at was 1915I. And there is a little bit in 1915C about conflict of interest, but as I said, I don't think that changed significantly or much at all, and I think that most managed care organizations will probably be able to describe it such that it seems like it is a separate enough program to meet the conflict of interest standards. Now, whether that works in practice or not is a different question. I think that most advocates have seen where care coordinators or case managers are sort of trying to follow the rules when they're connected. Maybe they may try to follow the rules a bit more when they're connected to the managed care organization, but based on what the conflict of interest standards say, the managed care organization can usually describe it or set it up in such a way that there really is supposed to be that separation. Then it's a matter of how the care coordinator or case manager discourages or not the individual's ability to ask for the services they want or need.
And there are a couple of other questions that have come up in the meantime. One person asks, what if the services that someone signs for are generic or neutral and they are told to sign? Is this a concern?
I think that anytime services are generic or neutral, it is very much a concern, because that means the person-centered planning process is not working. as described in the regulations, the person-centered planning process is supposed to be rather specific and supposed to really describe what the person is going to do with the services and how those services are going to meet the individual's needs. And so if a care plan just said, Bobby's going to get 40 hours a week of personal care and he's going to get 25 hours a week of community networking or some sort of community outreach services and 10 hours a week of supported employment, and then it says nothing about what that service is going to look like for him, that would be a concern. It means the person-centered planning process isn't really happening very well.
And the final question is just whether there will be a transcript for the webinar, and the answer to that is yes, we will have a video and transcript of the webinar up probably by the beginning of next week.
And because of that transcript, I apologize for all of my ums.
Oh yeah, we'll clear it up a little bit. And actually, this might be a good point to admit that I started recording at maybe like halfway into slide number 1. So there might be a little bit of a quiet part at the beginning of the presentation that we put up, where it's just transcripts and not Elizabeth talking because I hadn't started the recording. But there should be a full recording up on YouTube.
And just to confirm, I was reading specific for the 1915I requirements. So they are slightly different for 1915C and K.
Is there any more questions? Because this is a good stopping point. Are there any additional questions?
No.
Okay. I swear I don't have control of this.
Does that work?
Yep. Thank you. So we were discussing a little bit about person-centered planning, and there may be a way to use person-centered planning to help a person access the services they're supposed to have, or remediate some of the problems they may be having with their services, in that they're not meeting the standards, or especially if they're not meeting how the services are described in the person-centered plan that they agreed to. So the person-centered plan process is, I think as we all recognize, is really central to making sure that these rules are implemented correctly and for an individual, and that the person-centered planning process is also essential to making sure that modifications in a provider-controlled setting are done properly. And because person-centered planning is so key, it may also be a way to enforce the individual's ability to access the services that they're supposed to have. So as I said, the person-centered planning process is the way that the modifications are done for a provider-controlled setting. And the modification process is supposed to be done in a very specific way and make sure that the person's rights under these rules are not abridged unnecessarily. And so if that happens incorrectly, or if the modification is implemented in a way that is different from the person-centered plan, you may be able to go back and use the person-centered plan to say, we need to redo this because this is not working, not everybody's on the same page about how either the services are supposed to be delivered or any type of modifications are supposed to be used. So we think that you could probably use person-centered planning sort of like a person may use an IEP in the education setting, where you go back and revisit it if something isn't working right. The rules specifically say that the person-centered plan or the individual service plan can be reviewed when the person's needs change significantly and at the request of the individual, the authorized representative, or the healthcare provider. And I think that this is sort of the first step in trying to remediate a situation, because in theory, if the people involved in the person-centered plan should be the ones who know who know what the person's needs are, who were at the person-centered planning meeting when the needs and the services and the modifications were described and set forth and agreed to. And that means that usually those same people, you get them back together and describe the problem, that they should be able to either adjust the plan, adjust the modifications, or in general address the problem. I think that this would probably be the good first step for anybody to try to remediate a problem. It would also draw attention to what the provider is or is not doing. So for instance, if a person has a modification about they have a lockable door, but the manager of the provider-controlled setting has a key, and the key is only supposed to be in control of the manager. If the individual is like, well, there's the key is on a bulletin board by the front desk or in the kitchen, and anybody can access the key, and they do. So the person could say, all right, I'm going to call my case manager, and if the case manager either can't solve it or wants to have a person-centered planning meeting about it, you come back around and say, okay, this is not what the modification is supposed to be about. Do we need to be more specific in his modification to say that the key is supposed to be in control of the manager at all times, and not be accessible to other individuals to rewrite the modification. And the same would be true if the services, as they're described in the individual's plan, are supposed to say, are indicating that the person's level of community is supposed to be a certain thing, that they're supposed to be able to go do volunteering, and the plan indicates or is written such that it's volunteering on an individual basis to have community integration opportunities, and the provider is making all of the residents in a 3-bed group home do their volunteering together and travel to do it and participate together in all of those things, then that doesn't necessarily meet what is described in the individual's care plan, and they may be able to use the person-centered planning process to either adjust the description or find a different service that better meets the needs of the individual to have individual community integration hours, or have a person come by and pick them up, whatever the service may be that they can use to not always travel as a group with all the other residents, because having to travel all together as a group with everybody else who lives in your residence is more of a harbinger of not necessarily institution, but sort of institutional-like qualities where everything has to be done together. So I think a person-centered plan would be a person-centered planning meeting to adjust or further describe something in a plan would be a way to make sure everybody understands what it is supposed to be the person needs and has under this services. And then, of course, if you get denied your services, you can try to go through the appeal mechanisms or some of the earlier mechanisms we discussed. And so the next part that we're going to discuss, Elizabeth's going to take over, if we go back, there we go, is about how Olmstead interplays with some of the Medicaid regulations I talked about, and also how Olmstead is a part of, or a big part of these regulations, and some of the arguments to be able to use just based on Olmstead and not Medicaid.
Great, nice introduction, exactly. Elizabeth has just gone through different options for enforcing your rights, or possible options when it comes down to enforcement of the reg, and she's gone over Medicaid in particular and due process, and then other enforcement agencies, but everyone always wonders, well, how would Olmstead apply? And so the first thing to know that a state's obligation to comply with the ADA and Medicaid requirements are separate. And so a state must comply with the Olmstead integration mandate. But there is no rules for how they must comply. It's just that so many of the home and community-based services offered by a state are offered through the Medicaid program. So they're inextricably intertwined. But if a state had wanted to figure out a way to comply with Olmstead and provide appropriate community services without ever changing their Medicaid program, they could. So that's what I mean by a state's obligation under the ADA, and specifically the ADA integration mandate, are independent from the requirements of Medicaid. That said, most all litigation that's gone on and policy change has revolved around how do we change the Medicaid program, since it is the primary source of providing home and community-based services. How do we change it so that it makes more community-based services available? Okay, so in order to comply with the ADA integration mandate, a state may be required to provide services beyond what it currently allows in the Medicaid program, if doing so does not require a fundamental alteration. So basically, under the Americans with Disabilities Act, if a state can make a tweak to its Medicaid program in such a way that it's a reasonable accommodation to allow a person to be included in the most integrated setting appropriate, and the state can argue that it's not a fundamental alteration to the way it runs its Medicaid program, then the ADA integration mandate would require this. So that's the connection. And a denial of an ADA request for modification is an enforceable right. You can go to court and claim, without even bringing in the Medicaid Act, that the state is, well, you would probably bring in the Medicaid Act, but you would say the state is running its Medicaid program in such a way that the only alternative I have is to go into a nursing facility. And if they made this one reasonable accommodation to the program, I would otherwise not be unnecessarily institutionalized. So, hey, that cat looks like my cat.
Oh no, I don't know why my cat.
Oh my gosh, that looks like my cat.
On doing this, but it's really.
All right, let me see. Beyond that, oops, I just hit. Okay, go back. Let's see. Okay, that was my little explanation. But the Department of Justice, which is the agency in charge of implementing the Americans with Disabilities Act and developing the rules which have created the ADA integration mandate, they actually specifically say in, or CMS says in the comment sections of the HCBS rules, they actually address this issue, and they say, we believe the rule, the new HCBS rule, supports Olmstead principles. Within future guidance, we will reinforce the importance of complying with ADA and Olmstead. And I'm not sure that that future guidance has come out, but they are basically saying that by changing these rules and making it more and getting rid of outmoded models of providing community integration, in a sense, you're coming more into compliance with Olmstead. That is, if the HCBS waiver services that are being provided are not really allowing for appropriate community integration, then is that really complying with the ADA if you're offering an individual only a group home setting and you have no other options in your community or your infrastructure? Okay. So the HCBS rules can be a source of information on what community integration looks like, but there is a danger of a state saying, well, I'm providing this these different group home options, and I'm complying with all the CMS rules, and so therefore this is a community-based setting, and you, Miss Martha Jane, can't argue that Olmstead requires you to be provided services in in a community-based setting, because you are in a community-based setting. The difference is that Olmstead requires services in the most integrated setting, and the CMS rules just relate to what qualifies as what qualifies for funding under a home and community-based 1915C or 1915I or K state plan amendment. So that just deals with when can you get funding for CMS funding. It does not deal with what's the most integrated setting that a person should be receiving in compliance with the Olmstead rule. So hopefully that makes some sense. I always like to provide an example of a case that the North Carolina Protection and Advocacy Program, called Disability Rights North Carolina, they had a client, I'll just say Marlo, and she had lived for years, probably over 10 years, in a independent apartment, in her own independent apartment. And the state was making cuts to state plan programs, so that without the state plan program supplementing what Medicaid HCBS waiver services would offer, she was not going to be able to maintain her living in an independent apartment. And so the state said, no problem, we're still going to be offering you placement in a waiver program, we just won't have these extra state plan funds to allow you to be in an independent apartment. And the Protection and Advocacy Agency was able to show first that she needed a reasonable accommodation. She needed to be able to live in an independent apartment because she had lived in a group home in the past, and because of the particular manifestations of her disability, it wasn't working out. And she was having trouble finding she would probably have trouble finding a waiver home operator who would allow her to be in the group home if what happened before would happen again. So therefore she said it's a reasonable accommodation for me to be able to live in an independent apartment, and that's the most integrated setting for me. And that's an example of the difference between just being in a community-based group home and being in the most integrated setting appropriate to you as an individual. So,
well, Elizabeth, I can add a little bit here. I want to remind everybody that it's the most integrated setting appropriate for the individual's needs. And so it's really looking at what works for that person in particular. And the example of the Marlowe case is a good one. And there's also other cases that sort of go to the other side of that, that sometimes it's difficult to prove that having to live in a less independent setting is going to no longer meet your needs or not be the most integrated setting for you. I think the key thing to remember is that community integration looks different for everybody, and sometimes there's a struggle there with trying to convince states or managed care companies that they're one-size-fits-all package for community integration, that you're supposed to do this and this and this every day, and these supports should work, are not always really going to work for that person. And so it's sometimes a struggle to say this is what integration means for the individual, but that's what the purpose of the person-centered planning regulations is about, is trying to really look at the person and see what their needs are and what does integration really mean to them and what supports are necessary for them to be successful in the community. Because it doesn't, for everybody, going to supported employment every day or going to a volunteering activity every day may not be what they need to be fully integrated in the community for the other parts of their day. So I think that just to remind everybody, it's about what the individual needs and what does community integration mean for them. That is not to say that if they say community integration means I want to go work in a sheltered workshop, that's not going to be community integration based on these rules.
Yeah, and that's why so many people have been saying to me, and probably to Elizabeth, well, can you just provide a checklist for states to use for them to know whether they're meeting the new HCBS rule requirements? And the concept of true community integration is individualized, and therefore you can have a checklist, but you're going to be having to look at, on an individual level, can your policies and programs be reasonably modified to allow for individuals to have truly person-centered services provided. And if the policies in the program are inflexible, if there's no easy way to make modifications based on an individual's need, then it might not be complying with the rule. And that's a hard thing to capture in a checklist that says, yes, we have a statute or a policy that covers this provision. So that's just an addendum on there to what Elizabeth said. So, the next couple of slides will go over mechanisms for states and advocates to monitor compliance. And these are ideas that Elizabeth and I came up with, and we would suggest that as you're working on your state transition plans, you look at some of these ideas and urge your state to incorporate them. There are many others, but again, this is part of just to help think through what could allow for these rules to actually be enforced and monitored. The first idea is one that Elizabeth went into a little bit earlier when she was talking about the person-centered planning process. But you might want to encourage your state to have, as the first step in the person-centered planning process, to require an accessible resident survey. You know, what we've seen in plans so far is they'll say, well, we'll use a consumer satisfaction survey, we'll do it once a year, and that will help us know how things are going in this group home and whether the rules are met. And in many state plans, you just see a provider assessment survey, so it's great to at least have a consumer assessment survey as well. This is suggesting that you use a consumer a resident and resident assessment service every time before you begin or as part of the first step of your person-centered planning process. That can help you identify maybe some of the policies, unwritten policies and unwritten procedures that are actually hindering the individual's full access to the community. Getting an independent survey free of provider influence would just give you a lay of the land there and help you to understand what the individual wants and how things are really working in their home. And there are all different ways to do person-centered planning, and there are some existing tools, and that's fine. But it is possible to include as one of your steps an accessible resident survey to just help you. One more tool you can use to help you identify how the policies and procedures in your in the individual's home may need to be revised or changed. So the next idea we have is to require the licensing surveys to reflect the new rule. Now, I'm not suggesting that the licensing survey agencies should be the only entity to monitor for rule compliance, but since most states have requirements for survey and certification, one possibility is to ensure that those surveys have a way of reflecting the new rule requirements. What an advocate could suggest is if there is any kind of transition plan committee or advisory group to be able to look at the existing licensure surveys and suggest how to make those surveys more reflective of the rule. And as I said, we don't want just the licensing surveys to be the ones to review for this unless they're because there's already such a shortage of licensing surveyors as it is. If they suggest this, then also suggest they have additional staff brought in, and that the staff that's brought in be specifically trained to survey for rule compliance. We would also recommend an independent mechanism apart from the agency complaint process or the state survey certification process, apart from if it's a managed care program filing a grievance, but a completely independent mechanism to accept complaints that are specific to the HCBS rule. Right now, you know, I guess you could go to your CMS regional office, or you could file a human rights complaint, some of the other mechanisms that Elizabeth mentioned earlier, but there's no reason why they can't set up a specific mechanism to have well-trained people who could look at HCBS rule compliance issues specifically. And that would be something to suggest in your transition plan. And then Elizabeth, were you okay? And I'll turn it over to Elizabeth to. Was this the one you were going to go over, Elizabeth? No, actually, no, I'm doing this one. If I can go back a little bit, sorry about that. Whoops. Oh no. One more. Okay, so here are some more mechanisms. We would suggest requiring on-site CMS reviews for rule compliance, and similar to what I was saying, an independent. It could be you have both the independent reviewers, but then you would make sure that CMS at least reviews on a regular basis on-site. Right now, there's no formal procedure for doing so. I mean, this wouldn't necessarily have to be every year, but I am from the National Disability Rights Network, so I'm often thinking in terms of what the protection and advocacy agencies can do, and they are federally mandated to be in every state, and they have experience identifying issues regarding like what is true person-centered planning, what is true community integration. They also have existing federal authorities that allow them to access community-based settings and do monitoring in certain circumstances. So one possibility would be for CMS to fund the protection and advocacy agencies to do regular on-site reviews and have P&A staff members who are specifically trained in the rule. That I basically put that down as an example of leveraging existing services. But whether it's the P&A system or another system, CMS needs to step up and tell stakeholders how they plan to do long-term monitoring and compliance, besides just a paper that the state sends in every year and says, checks all the boxes and say, we're doing this. Okay. Another suggestion is to allow residents to complain directly to the licensing agencies and actually get a response. In many states, there's no formal mechanism for a resident to complain beyond the setting in which they are, and in those kind of cases, sometimes there's a chilling effect to doing so because you can fear retribution if you're seen as the squeaky wheel. Another possibility to expand existing state resources and to do monitoring is right now you have the long-term care ombudsmen who are they're non-legal, but they're individuals, oftentimes volunteer, that are in are present in nursing homes in all states, and more of them are getting authority by the state to also go into community-based settings. And so, again, one possibility just to get more eyes looking out for both the rights of individuals in community settings as well as full compliance with this rule would be to provide training and funding to ombudsman programs to monitor for rule compliance. Then next slide. Yes. Okay. And Elizabeth, I'll let you take over on this one.
Thanks, Elizabeth. So as Elizabeth Prio just discussed a little bit, those ideas are ones to suggest or advocate for in transition plans, and they're very similar to some of the ones I talked about earlier in terms of compliance, or they're an extension of possible avenues within a state for compliance. And I think our point here is that if your state doesn't allow for it as a compliance mechanism currently, it's options for advocacy in transition plans to say, hey, let's use these existing sort of mechanisms and expand upon them to allow for them to act as a compliance avenue. And as Elizabeth said, there's not, just having one mechanism for complaints is really not ideal. You would want more than really just one. So those are just ideas to think about. And our next little section is some of the problems that people may want to watch out for as this process moves forward. And I do want to remind everyone that although these rules, so the rules for person-centered planning are currently in effect, and anybody's person-centered plan that is happening now should be following the person-centered planning guidelines. I don't know that all states are there, mainly because some of the states in their transition plans are including language about, we're going to do education and training to our case managers and care coordinators about person-centered planning. But CMS has been very clear that person-centered planning rules are already in effect. They are not supposed to be part of a transition plan because they're not, it's not supposed to be something the state is transitioning towards. They're supposed to be already doing it. The CMS Q&A on the rules did provide a little bit of guidance about how and when person-centered planning changes should be occurring, or if a person's plan year is falling in sort of the middle, what happens. But so person-centered planning is supposed to be in effect, but the rest of the regulations, the ones we're talking about in terms of enforcement, are not in effect until March 17th, 2014. And more importantly, for enforcement, the states have up to 5 years for their transition plans. And so whether or not you can enforce something is really going to be dependent upon what CMS has approved for that state's transition plan. So for instance, if CMS has approved a transition plan for your state that says that provider assessments don't have to be, provider assessments of whether or not individual providers meet the home and community-based standards don't have to be completed until 2016, you may have a lot of difficulty trying to enforce that an individual, a certain individual is not in a community setting because the state hasn't transitioned to evaluation and compliance for all providers of home and community-based setting services. So that is one thing to keep in mind, that these rules, although they're in effect immediately, they are not really going to be seen in a person's life or in their services necessarily until the next couple of years. So you can't go forward and say, I want this setting right now because the rules say so. It's going to be largely dependent upon what CMS has approved in a state's transition plan, because CMS's approval of that plan gets a level of deference, and so that's going to be followed. And that is a bit frustrating because we have these rules and we want to make people, want to give the services to people as they're described now, but at the same time we want to make sure that these transition plans really do happen and they push community integration forward as much as possible. So if a state's taking a slower transition plan is going to get further along or has more changes to make for community integration, that's kind of a good thing that they're actually going to make those changes. So just keep in mind that you always have to look at both. You should always be looking at your waiver document or your state plan option document for 1915I and K, or the waiver itself for 1915C, to make sure what is described and approved for that waiver or that state plan option, because things can be waived. I don't know what CMS may or may not waive in these rules, probably not much, if anything. But always look at your state plan or your actual waiver document to see what's described. And then also in the next couple of years, you're going to have to look at the state transition plan and see where your state is to make sure you understand what is supposed to be done now and what you should be able to be trying to enforce now. Like if the state's supposed to be done with evaluation of residential settings, then yes, go ahead and push on that. But otherwise, just keep in mind those two big things, that you want to look at your waiver and you want to look at the plan before you really say this is what's supposed to be happening right now for this individual. But person-centered planning is supposed to be happening. So some of the problems that we think that people may see or that we're concerned about are the use of assessments is really common in person-centered planning to identify the person's needs and then use that to identify the services they should get. We are currently unclear that all of the assessments that states use or managed care companies use are going to identify community integration to the same standard that these rules define community integration as Elizabeth talked a little bit before about sort of what states or managed care organizations see as community integration. It may be that their assessments are standardized to community integration being a 4-bed group home or a certain type of living situation based on a person's identified needs based on their disabilities, which is not really how person-centered planning is described. And so one thing to look out for is the assessment identifying the level of services based on the community integration standards set forth in these rules, or is it normed for an older idea of what community integration was supposed to mean. Same is true for the budget. Usually these assessments help determine budgets. And so is the budget provided for the individual sufficient to allow for community integration? An additional issue here could be if the budget's determined and the person has no right to appeal a budget reduction, that would be an additional due process problem because a decrease in budget is related to services, and so that would be decrease in services. Another issue would be similarly related about case managers identifying needs based on what the budget allows and not on what the person needs. And we've discussed that a little bit already.
We have some questions from the audience. Is this a good time?
Yeah, sure.
Okay, sure.
And we have about 15 minutes left. One person was sort of asking about this budget issue, saying that changes could require additional dollars, and that he was expressing concern that if we put compliance into licensing schemes, then you're creating sort of additional responsibilities for group homes without providing additional funding. And what do we suggest in those cases?
Well, in order to comply with the new rule, there is probably likely to be new funding required, and so that would be my response. One of the reasons that we mentioned working with survey agencies or long-term care ombudsmen or PNAs are to try to utilize existing structures already in place for monitoring. And just making sure that training and information is provided so that people who are already the eyes and ears in those settings know what the new rule requires. So,
our second question is what happens when the planning process is there but it's not actually being enforced? So a person's got a plan, but they're not actually getting services that meet the standards that the plan seems to be outlining. Is the best approach to modify the plan or modify the process?
I think that would be a point where you're saying, okay, there's something wrong in the process, but I think the first approach would probably be to try to modify the plan and make it more specific. And then there could also be a general complaint about the process. As I said earlier, if the failure to provide the services was rising to the level of an action, that would be maybe the next step a person could take, is that if they try to modify the plan, it doesn't work, or if it's so egregious it's rising to the level of essentially denying the individual services or the type of level of service such that it's an action, they could possibly then access the Medicaid appeal process. But I would probably first step look at modifying the plan.
All right, thank you.
Likely because it's going to be quicker.
And one person asked whether states are required to pay for these assessments that we were just mentioning.
Assessments of providers or assessments of individual need?
I'm not clear based on the question, so let's just assume.
Okay. So the assessment of providers we were talking about is a lot of states in their transition plans are saying that providers, in order to determine whether or not providers meet the standards of home and community-based services set forth by the rule, that providers would fill out like a self-assessment survey. And those are the assessments we're talking about for provider assessments. The ones that Elizabeth was mentioning about having other groups do assessments, as she said, that would maybe require additional funding from a government entity, either the state or other. And assessments of individuals, in that instance I'm referring to for most waiver services or even state plan options for K or I, there's usually an assessment process of the individual to determine the level of need, which then usually determines the types of services that a person should receive under the home and community-based services plan. And those assessments are usually paid for through the Medicaid process.
I would agree. And states know how to get administrative funding for those kind of administrative services.
Usually those assessments are done every couple of years or every year. It's not, but so frequently.
We've got about 10 minutes left to finish the presentation.
Well, this last slide actually was, it's not imperative if there are more questions.
Yeah.
Yeah. Are there more questions, Sam?
We have, let me go back and look.
I will say quickly, while Sam is looking for more questions, these problems are fairly well laid out on the slide about additional problems. One of the things we didn't talk about when we were talking about Olmstead was a possible theory of whether or not you could treat a denial for additional service, a denial of a request for a reasonable modification under the ADA or via Olmstead as a denial of Medicaid services. And I think that's a bit of an untried theory in most states. But if you're asking for additional services and those services are denied, there's certainly an argument that that should be treated as a denial of Medicaid services.
I don't see any other questions, so we can...
Okay. We'll go through these last ones real quick and then finish up. So some of the additional problems to look for, sometimes states do not provide EPSDT services to kids on waivers or in community-based services. So there's guidance by CMS about how states are supposed to blend services under EPSDT with waiver services or state plan option home and community-based home and community-based services. And they really are supposed to provide a child with all the services that are medically necessary to correct or ameliorate a child's condition, usually before the child accesses the waiver services or the other home and community-based services options.
Yeah.
But most states don't do it that way. It's not a major problem unless the kid is not getting the services he or she needs. But just because a kid is on a waiver doesn't mean they shouldn't be receiving all other necessary services through EPSDT.
And one of the reasons that we put it in is because as more and more states go over to Medicaid managed care, managed care, since it's not used to serving folks with disabilities under Medicaid, one of the areas where we see chronic problems is just an misunderstanding of what the early periodic screening, diagnosis, and treatment program is. So they'll say, well, the child is entitled to a well-child visit, and I'll go through the same checklist without realizing, or just thinking, okay, this person's on a waiver, they're going to get only those waiver services. And as Elizabeth just said, there's a higher standard. In waivers, the standard might be medically necessary, and then you have the ability to cap services and other rights that aren't the case for kids under 21. So if they're eligible for a waiver, they're automatically eligible for this larger benefit that doesn't have to be capped. And as Elizabeth said, it's to correct or ameliorate a problem as opposed to just medically necessary. So, yeah.
And I will say that EPSDT does not apply to all services that would be available under a waiver. So that was something just to make sure you understand what EPSDT applies to, and before just saying that EPSDT should mean that the child gets everything. For certain things like respite are not covered by EPSDT. It's just a waiver service.
Right.
Other issues that are common, I think a lot of people recognize, is a failure to provide services pending appeal. Also, issues about provider qualification standards not being met, or if there's not enough providers so that there's not enough access, and how the state should be encouraging more providers, especially with the home and community-based standards rules, that there's supposed to be an array of options. States have a duty to at least try to make sure there's access to services. Other problems, the rules are fairly clear about what the role of an individual representative is, and so that would be something to watch out for as the person-centered planning is moving forward and changes are being made to that, because it's very clear about what an individual representative's role is versus that of the individual who's receiving the services.
We have a couple more questions that I think we'd like to get through real quick.
Sure.
One person says, for EPSDT, will habilitation services be required under EPSDT now that the ACA is requiring it?
So CMS actually issued a Dear State, I think it was a Dear State Medicaid letter director memo about that. And actually one of my coworkers at NHELP recently wrote a short Q&A on habilitative services and Medicaid based on the changes that CMS, or the interpretation CMS offered in that letter, which is currently available on NHELP's website at healthlaw.org. It's written by Abby Corsell about habilitative services in EPSDT. So
Great. Another person says, what about individual needs assessment if they're not currently paid under Medicaid, but the state requires that assessment in order to pay something out? Is the state required to pay for it, and what rule would require it?
Usually, in terms of waiver services, from my experience, written into the waiver is basically where it says that the state can pay for, through Medicaid, assessments for services. Usually the way the entry mechanism works is either the Medicaid agency, there's a screening process to determine who should get assessments, and usually that's paid through by Medicaid.
And finally, there's one person asking, how can we avoid unnecessary deference to guardians? And does that mean that you intervene in the guardianship proceeding, or how else is a disagreement between the planning provider and the guardian gonna be worked out?
Let me go back. I had a second thought about the previous question, then I'll answer the one about the guardian.
Sure.
For certain eligibility requirements, such as whether or not a person has an intellectual disability or would meet a certain level of care, sometimes those type of assessments are not considered part of the waiver assessment process, and those aren't always covered by Medicaid. They would be covered because it's so early on in the eligibility process. They're either covered by something else, or the individual has to find a way to have that happen. I didn't want to imply that Medicaid pays for all types of screening services for a waiver if the person's not currently on Medicaid. Although there is some degree of ability in the waiver to pay for some things at some point. That's not very specific, but I would look at your waiver. In terms of the individual representative, I thought the new rules about individual representative and the role of it are very interesting. I think it would be one way to do it was to make sure that the person-centered planning trainings that a state may be doing for care coordinators or case managers is very clear about the role of the individual representative. And that would be something a person could complain about in a process if it's not happening right or afterwards. I am always a big fan of making sure that a person has as limited guardianship as possible or has alternatives to guardianship to accomplish the same needs. So if it is an individual who doesn't necessarily need full guardianship, then there's certainly alternatives that they could do in the guardianship proceeding to make it much more narrow about what they need help with. But I think the main thing is making sure there's proper training and there's proper policies in regards to person-centered planning to reflect the role of the individual representative and complaints afterwards if need be.
And I would like to add that even if the person, does have a guardian coming into the person-centered planning process, we're not necessarily saying that the person-centered planning service provider has to challenge the guardian's legal authority or get involved in guardianship court, but simply having a guardian doesn't necessarily mean that the person-centered planner has to do without question, has to accept the guardian's input without question.
Yeah, Samantha, I think that's exactly what we meant when we were putting it down. I agree with what Elizabeth said, but I think the reason we put watch for problems is it was unnecessary deference to guardians. It's not that if you have a guardian and let's say it's a plenary guardianship and they are allowed to have some say in person-centered services, we want provider agencies to know that just because they have a guardian doesn't mean it's a plenary guardian, and they get to have control over all instances. And because in the Olmstead context, there's so much of a problem of just automatically deferring to the guardian without finding out whether there's proper authority to make, services regarding residential settings. And so I think you said it much better. But
I would just be clear that the individual representative rules, the rules about individual representative are quite clear that the person who's in charge of the person-centered planning process is supposed to be the individual receiving the services.
Even in cases where they have even a plenary guardian.
Yes.
We see this in the medical context quite a lot, where if someone has a guardian for medical care, and the guardian says, I want them to get this surgery, but the actual patient who's getting the surgery says, no, under no circumstances I'm not getting it. The doctor is not going to perform the surgery. Even if the guardian has legal authority, the doctor has the prerogative to exercise discretion in terms of medical ethics and not perform a medical procedure on a non-consenting person. Just because a person has a guardian doesn't mean that you don't have to involve that person in the decision about themselves.
And I think the reason we put down the failure to provide accessible services, not only because that would be potentially an Americans with Disabilities Act violation, but also it goes back to, for example, one of the examples that Elizabeth provided earlier, where do you have a lockable door? Why, yes, but the key is maintained over behind the front desk. So, you know, in those kind of circumstances, oftentimes it's the person behind the front desk. It's not going to be wheelchair accessible, or it's not really going to be all that accessible. If you, and so there's accessible as in accessible for wheelchairs. There's also accessible. Well, you just look at the way a community setting is offered, and if the individual has freedom to come and go as they please, but there's not a good quality accessible entrance, then is that really freedom to come and go as they please? And accommodations may need to be made to the physical setting to allow for true independence.
And that is a non-modifiable provider-controlled setting provision that cannot be changed. It always has to be accessible to the individual, which doesn't mean it has to be ADA accessible. It just means it has to be accessible for that person.
Right.
Great.
And so I think and that the person-centered planning process is supposed to be accessible for the individual in terms of program access. Understandable. So I think that's the end of ours.
That's the end of our webinar. We've gotten to 2:30. Thank you, everyone, for joining. Thank you, Elizabeth Prio and Elizabeth Edwards, for presenting this excellent webinar. This is the end of our series, but at the end of the day today, you should receive the slides, and at the end of the week or beginning of next week, we will have a recording of this webinar up on the internet for anyone who couldn't see or who couldn't join us. Thank you, everyone, and have a great day.
Thank you.
Thank you.